appears that we have all of our counsel with us. Let me do the housekeeping first with Attorney Allison. You'll need to unmute, as will your other counsel, when it's time. We need to make sure that I have all the time. I think you have the rebuttal on this, and I think the intervener, well, let me see how you want to do it. You have, of your 20, how much did you wish to reserve for rebuttal?
Judge, I'd like to reserve 5 minutes for rebuttal.
And you would be rebutting both the AE and the intervener?
No, the
No,
intervener.
you would just be rebutting the AE. The AE will need to reserve the appellee some time to rebut the intervener. Is that correct? So that would be Mr. Dogali.
Are you asking me?
No, I'm asking Mr. Dogali.
Oh, no, sir. I believe for purposes of this appeal, there won't be a rebuttal of any intervener position for the appellee.
So then I just need to do 15 for the appellant, 20 for the appellee, 10 for the intervener, and then 5 for the rebuttal. Do I have my administrative marching orders proper?
Yes, Judge, from my position.
Okay.
Your Honor, is it possible that the intervener, because the appellee may raise certain issues, that the intervener would have, say, 8 and 2 have rebuttal time for whatever intervener specific issues?
I'll wait to hear from Mr. Widener if he needs any time as the intervener. Is that correct? You need to unmute.
Judge, I don't have any objection to what the intervener, Mr. Dogali, chooses to do with his time.
Okay, I'm sorry. I have Mr. Widener as on the intervener, but that is incorrect.
Yes, sir. I'm the appellee.
I apologize, sir. So, all righty. Thank you for that correction. I had so many moving parts. I didn't want to lose anything. So, Mr. Dogali, you wanted to do 8 and 2?
Yes, sir. If I may, 7 and 3, perhaps.
Okay, I think I have it. If not, I'm sure I'll be corrected when we get to the appropriate time. So I think at this point, we'll do the appellant's argument, appellee's argument. Well, let's see. Mr. Dogali, who would you be rebutting? The appellee?
Whatever the appellee may offer.
Well, if you're following the appellee, you're going to have an opportunity to rebut during your argument, right?
I did not recognize, Your Honor, I apologize, that would be the order of presentation.
Okay, well, that's why I'm trying to make sure I do this correctly. I've not had an intervener before. I'm making an argument and I don't want to cause any scheduling problems.
I've never handled an oral argument for an intervener before. It was my assumption the appellant would go first, the intervener would make its presentation, and then the appellee would counter all of those, but I don't really know the right way to go about it.
Let's see. Mr. Weiner, do you have any position?
I was going to say, if I get a vote in the matter that sequence as Mr. Dogali asserted is what I would like, Your Honor.
Okay. Then we will do 15, 7, 20, 3, and 5. Okay. Appellant followed by intervener, followed by appellee, followed by intervener rebuttal, followed by appellant rebuttal. Now we have all the players. We have a scorecard. I think we might be able to make this go, assuming that my technological skills continue to function. With that, we are ready to begin with counsel for the appellant. Attorney Allison.
May it please the court, I'm Ann Allison and I represent the appellants Dr. Drapp and Michael Strife. Mr. Dogali represents South Florida Lending. And this case is about a trial court that voided a deed without insufficient evidence. In fact, with using the wrong standard of evidence, There's a lot of facts. You probably noticed my fact section was longer than normal, but there are a lot of facts, but the legal end of it is pretty certain, and that is the appellee plaintiff below had the burden to present clear and convincing evidence that his client was mentally incompetent at the time or on the date that he signed the deed at issue. Now, the case started out with the appellant claiming that there was no such deed that existed. When my client produced the original, then they changed their position to that's a forgery, and then they again changed their position to I don't remember it, I was on medicine. So again, with a burden such as clear and convincing, that's kind of a confusing evidentiary burden, but it's a lot more than merely 51%. And it would seem to me in all the cases I've read that to prove somebody was mentally incompetent to the extent that they are that they have a permanent or temporary condition that renders them to a point where they are incapable of comprehending the nature and effect of the deed in this case. I would think, though I'm not an expert, but you would need some sort of medical evidence.
Counsel, there's a lot in the trial transcript about the condition of Mr. McDaniel as testified to by Mr. McDaniel. And there's more in there during trial testified to by Mr. Drapp. As you suggest, there's no medical testimony per se, but there's a lot of discussion about the fact that he was suffering from cancer and was in tough physical shape and didn't know what he was doing and had memory issues and on and on and on. I guess my question is, what is our role in terms of weighing whether or not that's sufficient to satisfy the standard to set the deed aside?
Well, first of all,
because of course the judge makes a lot of findings in the final judgment, a lot of findings. They're kind of all over the place. To include some of the findings that I just referenced that came out during the trial itself. In fact, it seemed to me that the judge commented on things that the notary testified to that the notary perhaps didn't actually testify to, but that's another story. So I'm just puzzled as to at what point or what is our role in terms of weighing whether or not that's sufficient to set this aside, because the whole case is rather peculiar when you consider that Mr. Streif, it seems to me when the dust settles, he's the only one that's actually out anything and he doesn't show up for trial. So I had a hard time figuring out who's on first, to be honest with you.
Well, Judge, there are a lot of facts that the judge stated in her final judgment that are not correct, as you just mentioned with the notary. But we know one thing, and we know that uncorroborated testimony does not constitute competent substantial evidence. We made that argument in our brief citing Dworkis versus Dworkis. And so if we start at that proposition, because while Curtis Drapp testified a lot, you notice they never specify any particular dates. They say at the relevant time, at the relevant, dates, but they never actually identify any. And at trial, I was the trial attorney. When I asked questions of the appellee and his witness, they couldn't even tell me the dates. And so as far as credibility goes, I would think you would know specific dates that you had cancer treatment or what it was. And they never explained how any of that affected his mental capacities on August 4th, 2016, when he signed the deed. That's the relevant question.
Can I ask you, let me ask you another question. You bring up as we're talking about the date of the deed, August the 4th, 2016, the tax bill that allegedly gave rise to all this was paid several months earlier. Is that right?
Yes, Your Honor, it was.
Because supposedly this deed was given in exchange for the $12,000 to pay off the tax bill, but there's no writing, there's no agreement, there's nothing I can find in the record that indicates anything about the 12,000 other than what was testified to. There's no, in other words, there's nothing that says, I'm not going to loan you this money unless I get some security in the form of a deed if you don't pay me back. They all sort of have that story, other than Mr. McDaniel, who says he doesn't know anything about any of it. But I just found it peculiar that the theory is that this deed was given in exchange for this loan, but the deed isn't signed until 4 months after the tax bill is paid. In other words, how do we even know that it was Mr. Streif's money that paid the tax bill?
Well, because they've deposed him 3 times, and Dr. Drapp and he both say, because she didn't have any money. She had just moved to the area and gotten a job, but she didn't have any money. And we all know that one person that saves his money instead of spending it. And she didn't even really want to borrow it from him because, and this is all in my brief, she didn't even want to borrow it because her dad already owed her a bunch of money and didn't pay her back. And she didn't want to be on the hook for it if her father didn't repay it, and he didn't repay it. And so I guess the moral of the story is she probably should have just let the tax man sell the property, and she would have been done with all of this, because all she got out of it was a headache. But neither here nor there. Back to the evidence, this is just purely an evidentiary issue from my perspective, and that is Curtis Drapp was not there. He was not one of the people there when he signed the deed. He drafted the deed, lied about it at trial, said he never saw it, but he drafted it. Appellee admitted, and it's in my brief, he admitted at trial that he knew about the deed. He never actually denied anything at trials. He never, he just says, I remember some of this and that, and I could have blocked it out. And the case law says if you can remember certain details, you're probably not incompetent. And he does remember details. But the only people whose testimony matters in this issue is the notary who knew all these people personally. And if you're going to call my clients scoundrels and thieves, I don't know why they would choose a notary that they all knew personally. Because the notary knew the appellee, knew appellee's ex-wife, knows the appellant, Dr. Drapp. So he testified in no uncertain terms and wrote an affidavit saying he would never have notarized something as a notary of 25 years. He notarizes only for people he knows. And he said there was nothing wrong here. There's nothing to see. And the only people there were the notary, Dr. Drapp, Michael Streif, and the appellee. So Curtis Drapp's testimony should be thrown out because he never specifies any dates in the first instance. They say at the relevant times, the relevant dates. It's almost a setup to try to hide or to dodge identifying any particular dates. But just based on the case law, someone has to be able to testify that at the particular time of the deed, to some medical certainty under the clear and convincing standard, which is a very high standard, that this was the case. And the clear and convincing standard, there should not be any peculiarities. There should not be any questions about that. And the judge actually never ruled that he was mentally incompetent to the extent he didn't know what was going on and didn't appreciate what he was doing or the effects of it. So we went in, the appellant went in without a burden because under Florida law, the deed is presumed valid, the grantor is presumed competent, and people are presumed to read and understand what they sign in Florida. So we walk in with those presumptions, which trump any inferences, by the way, that anybody could have. And so just again, if you get away from the emotional parts of this and look strictly at the evidentiary burdens, the plaintiff below didn't come anywhere near proving their case. They just had no evidence. And by the way, what's the credibility of Dr. Drapp's ex-husband testifying? They called her a thief at the divorce case and brought all this up and accused her of stealing this property. And then they, took their show on the road and came to this case and accused her of lying in the divorce case. And she is a pharmacist who adopted 3 children just 2 years prior, who has been cleared and investigated. And they've basically called her everything but an honest person. So, I am really floored by the nasty tone of this final judgment. The judge was recently transferred to the case. Had I known she had so many preconceived notions, I would probably have moved to disqualify her, which I would do on remand if we get to that point. But in any event, if you objectively look at the evidence, there is no way that the appellee met the high burden to prove the detailed condition of mental incompetence on August 4th, 2016, when the appellee signed the deed. And oh, by the way, appellee's witness, Curtis Drapp, wrote the deed, and they wrote the deed a couple months prior. So there was no trickery. There was no rush. They don't say when he was confused. They don't say whether it was when they agreed to the deed or when they finally got in the same room and executed the deed. So there's a lot of hedging going on. And I just think that under these circumstances that they don't come anywhere close to meeting the clear and convincing standard of evidence.
So your take on the case is pretty simple and straightforward then. They didn't meet the evidentiary burden and we ought to reinstate this deed, and that's that.
Well,
the evidentiary burden to find a lack of competency to execute the deed.
I would assume that if someone had the medical evidence other than their own testimony, and certainly Mr. Widener never had a guardian appointed for him. They just kind of made up these theories as they went. As we brought out more evidence, they'd go over here and they would, dodge it here and there. And
let me ask you this. In the judgment, I'm looking at the judgment. It says, according to all the evidence, McDaniel was gravely ill at the time he wrote his name on the deed. Specifically, McDaniel and witness Curtis Drapp testified that the plaintiff suffered acute symptoms of illness, which McDaniel and Curtis Drapp attributed to a diagnosis of stage 4 lymphoma cancer. And then it goes on and on. I won't read it to you, but there's about a couple of paragraphs with a lot of verbiage along those lines. Does that constitute competent substantial evidence to support the judge's final judgment ruling in this case?
Not according to that Dworkis versus Dworkis case I cite in my brief, which says, obviously the plaintiff has a self-interest that if he was so ill, he would have had some sort of evidence of that other than his own testimony. But that case says a person's own testimony does not constitute competent substantial evidence. And remember, you can look to Curtis Drapp, but he's very evasive in his testimony. But the important fact was he drafted the deed and then said he never even, knew about it. That wasn't true. But he wasn't there when Mr. McDaniel signed the deed. So his testimony doesn't matter under second DCA case law, which says you have to prove at the time you executed the deed that you were mentally incompetent which is to say that you had a temporary or permanent condition causing mental incompetence, rendering you incapable of comprehending the nature and effect of a deed in this case. And
Thank you, counsel. Your time has at this point expired.
okay, I'll keep my 5 minutes. Thank you, Judge.
You're welcome. We will next, according to our calendar of events, so to speak, we'll hear from the intervener's attorney, Mr. Doggally. Did I pronounce
Thank
that
you.
right?
Sorry?
Did I pronounce your surname correctly?
Dogali.
Dogali, thank you, sir.
Yes, sir. Thank you, Your Honors. If it please the court, again, I'm Andy Dogali. I represent South Florida Lending Corporation. I'll expand upon some of the concepts that were raised by Ms. Allison, and then supplement perhaps with some more peculiar to my client. In this situation, I think the court ought to emphasize or focus on two statements that are the linchpins of the underlying judgment. The first is at page 2, and the court finds that the defendant failed to present any credible explanation of why the plaintiff would voluntarily and knowingly transfer his interest. That is, the defense failed to prove that he intended to convey the property. That statement standing alone, she actually phrases that as the predicate for everything that follows it. That one manifests on its face that this is a reversal of all the presumptions Ms. Allison talked about, in that the trial judge declared intent dispositive of validity of the deed. She found first that he didn't intend to convey, and then declared the deed invalid for that reason, which is backwards. All of these presumptions, Your Honors, actually arise under 90.304 of the evidence code. These are not presumptions that give rise to a duty to just produce evidence and thereby you rebut and switch to the other side for presentation of proof. These require actual proof by the plaintiff of these components under the evidence code. And as Ms. Allison mentioned, there is no proof. There's certainly no medical proof. And Judge Black asked about, well, what about the testimony that the individual gave? The testimony the individual gave, the individuals, including Mr. Drapp, included no temporal component at all. And the temporal component is critical here because they knew from the start that an element of their case was incompetence at the time he signed it. They refer 12 times in this transcript to what's called the relevant period. And it's defined as a 4-year period of 2014 through 2017. The closest any of them get to offering a temporal statement about that is that he suffered from chemo sometime during probably 2015 and or 16. And according to Mr. Drapp, during the entire 4-year period, Mr. McDaniel was physically incapacitated, not mentally, but physically incapacitated 30 to 40% of the time over that 4 years. There's nothing about what happened that day with respect to the 2016 deed, except Mr. McDaniel himself, who recalls signing it and didn't remember other than I might have disengaged my brain that day for a few minutes. That's literally all that the temporal component includes. So there's this 30 or 40% over 4 years and this Mr. McDaniel himself. Now that gives rise to another aspect of this judgment that is a bit odd, in that the judge set aside all 3 deeds. To the extent there might conceivably be temporal evidence about the 2016 deed, there's none about the 2 2017 deeds, or more importantly, the 2014 power of attorney under which they might or might not have ultimately been conveyed to South Florida Lending Corporation. So this, somehow you're supposed to guess at where the 30 or 40% falls within the 4-year period. And the judge invalidated deeds that were executed in 2016 and 2017, arising out of a power of attorney in 2014. Now, this idea of reversing the burden of proof to make intent dispositive of validity of the deed being sort of backward in the entire analysis, because we never should have gotten to intent. There should be first a determination of validity of the deed because of the presumptions. Then we get to intent when the court has to decide how to fashion declaratory relief, which is all anybody sought here, is declaratory relief. It was stipulated that everything else was not being sought. Now, the second statement in her judgment that is a linchpin for the rest of it appears at page 6. and reflects that the court finds that the 2016 deed was signed because of mistake, undue influence, and fraud. McDaniel never had the intent to transfer his interest. There isn't any evidence at all as to those components, that being mistake, undue influence, and fraud. Mr. McDaniel didn't say it was a mistake. The people that were there did not say it was a mistake. Fraud requires a representation that's false and some reliance. Nobody offered anything about that. Undue influence, the judge herself said that it's not clear whether Ms. Drapp had a fiduciary duty after 2015, May of 2015. So she did not find that a position of confidentiality and trust existed that would give rise to some fiduciary relationship that might create undue influence and therefore duress, et cetera. So there's nothing to support this notion of mistake, undue influence, and fraud. And in fact, the only thing that went into evidence, as Ms. Allison mentioned, there's no medical evidence at all, no professional evidence, with the exception of professional evidence that Mr. McDaniel put in himself. That would be the DCF report. It's a little odd to present that, but it was presented without hearsay objection. So it could be, the judge could have relied on it on its merits, and it contains professional opinions. It contains DCF's statements findings that he was not incompetent, and it contains his own admissions that he was not incompetent. He said he wasn't under the influence of anything else at the time he signed all that. Now, when this plays out this way, and the court deems his intent to be determinative of everything else, she also went out of her way, and I think Judge Black made reference to this, that she included some findings in her judgment that were actually never tried in the case. So what I hope the court won't do is that I hope you'll avoid the inclination to perhaps look for a separate independent way to affirm a judgment, as the court will often do. If the appellee is wrong as to one defense of this judgment, there might be another ground for affirming it. In this case, she has several findings that were not tried. So it needs to be clear those should never form the basis of an affirmance of even part of this judgment. And in any event, the 227 deeds have to be reversed as to those, because there was no evidence at all as to those, if there might conceivably have been some as to 2016. Now, the other findings that she entered, she at one point in the judgment said that the plaintiff elected to proceed exclusively on declaratory judgment, but she was going to make additional findings with regard to other allegations in the amended complaint anyway. So that's her statement that effectively these are what at your level in the appellate court would be dicta, that she's just going to make findings based on allegations of the complaint that were not presented.
Counsel, you're at 7.
I'm sorry. Thank you, Your Honor.
It's up to you. If you wish to go on, you still have 3 minutes left.
Yes, just a little bit. Those findings that were ancillary and just superfluous are, for example, the vulnerable adult standard. It's reversible to apply that standard at all. It's not a level of competence. It's much lower. There's no law to support that being a basis for invalidation. But the issue of vulnerable adult wasn't really tried in the case, because that was a Chapter 415 claim that was not presented. That count was dropped. There is a usury finding, apparently, in this judgment that was absolutely, it wasn't even pleaded, much less tried. And the judge admits that in her judgment, that she did that on her own. I just wouldn't want the court to think there are defenses to usury. It's a very sophisticated claim. None of those were appropriate for presentation. The final is she makes some references to whether South Florida Lending Corporation was a good faith purchaser. There were no findings and no presentation about that. And with respect to particularly with respect to the 2017 deeds, but there was nothing, for example, on she opined that South Florida Lending appeared to be an arm of Drapp and Streif, which there's no evidence at all about that. And she opines in her judgment that $12,000 is such a woeful small amount that it indicates there's not a good faith purchase here. There was no presentation for her to consider, for example, the other liens that existed against this property, whether it was encumbered by other mortgages, et cetera. So all of those findings I just mentioned, Your Honors, I encourage you not to avoid the temptation, if there is one, to seek an affirmance based on those. They're simply dicta. Thank you.
Thank you, counsel. Okay. We will hear from the appellee at this time. Mr. Widener?
May it please the court, counsel. I'm here today, obviously asking this court to affirm the well-reasoned 11-page long final judgment that was entered by Judge Allen. The judgment was supported by a significant amount of evidence. I would urge the court to consider that it was not just the trial testimony that the judge had to rely upon, but that she also had 6 depositions of three of Mr. Streif, 3 of Ms. Drapp, that were by agreement of counsel admitted in and that were considered by the judge. I would also urge the court to consider that the record reveals both sides also submitted a closing argument, as did intervenor in this case. And in all of those briefs, they raised all of the arguments that are before the court. Just for ease of my presentation here, I want to just focus on the appellants first and then get into the complicated and confusing issue of the intervenor. I think that's a separate issue that really muddies things up. But I do urge the court, obviously, to pay attention to the judgment and recognize that our argument at trial, and it really is the finding of the judge, is that even if the deed was in fact executed by this vulnerable gentleman, this gentleman that was clearly sick, that was clearly infirmed, and Judge Black, you questioned about the judge making those findings. She got to see him on the stand. She got to hear the testimony.
Can you direct me to the evidence that you find most persuasive that he was in fact clearly infirm as of the date in August 4th, 2016, when he signed over the deed? Because I read the judgment many times and I saw a lot of references to him being ill and having various issues, but none of them actually talk about the date in question that the deed was executed. They kind of are sweeping, and it's kind of hard to tell what time frame she's talking about or exactly what it was about his treatments that compromised him intellectually in some fashion. So what is it as of that date? What can you point me to?
I would point you to the trial testimony when there was significant conversation in dialogue, evidence from Ms. Drapp, Dr. Drapp, about where he was and what he was doing. I was questioning her in that trial transcript about where he was living. I believe the testimony was that he was living with him at some point in time, but immediately prior to that, he was so ill that he wasn't able to use a bathroom. There was a chair next to him. And so in the trial transcript, there is specific testimony about him being basically debilitated right around that period of time.
Well, I know I read all that, and there's also some things in the record about the various properties. He's experienced with real estate. Wouldn't you agree, based on the record?
Based on the record, sure. And so
even if he can't use the bathroom, for example, what does that have to do with his ability to understand a deed? I need something more specific, as there's certainly no medical testimony that really lays this out.
Sure. So I would point the court to each of the 3 depositions. In each one of those 3 depositions, the deponents, Streif and Drapp, talk about his medical condition, about him living with him there at the time. But I do want to focus on one thing in particular. Let's assume that everything that they said is correct. The judge found that the deed was executed, but the problem or the reason why she invalidated it was under the horrid finding that he didn't firmly convey it. In all of the transcript testimony and all the deposition testimony, it is clear that the appellant's own position is that this deed was not given immediately to say, here, take possession of. You said deed given in exchange. No, all of the appellant testimony was that it was given as security. If you remember in the depositions where I excerpted out 8 pages for Streif and 9 pages or so for Drapp, and where I kept asking them, you said Dad gave a loan. Yes, Dad gave a loan. You said we hold the deed for security. Yes, the deed for security. So what all of that represents, 6 pages or 6 depositions and the trial testimony, is that, you know what, even if he signed it and the judge says, hey, I think he signed it, okay, and gave it to Drapp, he never conveyed to them the property. And that's the standard there, is that he gave it to them and it was a free exchange, and he lost his ability to pull that back. And in the case law, both from Carpenter and Howarth versus Moreau, all of those talk about this concept. This deed, even the appellant's own position, when he signed it, whether he was sick or incompetent or whatever else he was, when he put pen to paper and handed them the original deed, even they admit their whole case was, we held on to that as security. And remember all that, and remember that was months after the alleged debt was executed. And remember all the testimony about Dr. Drapp and Streif and all that. Hey, after you had this original deed in your hand, Dad told you, quote, to hold on to it. Dad told you it was security. You said that it was security to make you get returned. In the trial transcript, when Ms. Allison is questioning Drapp, the first thing they talk about is that you're going to hold on to it. Well, they in fact didn't record the deed that's operative in this case. That's where the transaction gets even more wacky, is that she is holding on to the deed. Drapp, the appellant, is holding on to the deed as her dad told her to, as she agreed she was going to. He didn't surrender control over that. And she never recorded it. And that's a dispositive issue, an important issue, because under this concept of holding the deed or even providing a deed as security for a debt, he retained the ability to say to his dear daughter, hey, I got the 12 grand here, and before you go and make me homeless and take away $500,000 worth of property, I'm going to repay that $12,000. He was never given that opportunity. And I want to take a deep breath here and recognize the issue here, that we are talking about the $12,000. Most of the facts are not in dispute. And this, I think, is something that was important to the judge. It's in the opinion. We're talking about $12,000 that was allegedly owed a loan to Drapp by a guy that she didn't know, and a guy that admittedly McDaniel did not know at all. In the transcript, we asked, did you ever tell McDaniel that I borrowed 12 grand from this guy that he didn't even know? No, he didn't know. But it's $500,000 worth of property, conservatively. We all admit that. And to affect that he wasn't given the opportunity by his daughter, who was babysitting their kids. He was babysitting their kids around this period of time. They were right around one another the whole period of time. And he was never given the opportunity to say, hey, this deed's going to get recorded if you don't do anything. And again, back to this point, Drapp did not record the deed. It was only months after the fact that that original deed got recorded. And I really urge you to pay attention to that sequence of events. Counsel for intervener talked about this a little bit. When we filed the case, all we are aware of 2 power of attorney deeds. Judge Allen, in her opinion, says, I find that those power of attorney deeds are invalid because they could violate fiduciary duty and all these other things. But that doesn't matter, because in their own pleading, the appellants abandoned those two power of attorney deeds that were recorded in 2017. We file our case, they file their answer. They don't say anything at all about the disputed deed, which is the only thing at issue. It's only in deposition, months after the case was being litigated, that this disputed deed pops up, and the appellants say, hey, ignore those 2 power of attorney deeds. I quote in their motion for summary judgment, they say something like, they were in essence a waste of time and not relevant, don't mean anything at all, because those 2 power of attorney deeds didn't need to happen because we had the prior executed original deed, what I call the original or disputed deed. So they abandoned those power of attorney deeds and chose to say, just this deed that dear old dad gave us, the $500,000, is what's at issue. And then at trial, it's developed that what happens here is Drapp never recorded the deed. It was subsequently transferred to South Florida Lending, that original deed that we all agree, that all their testimony says they were holding on to as security. In some transaction where 2 guys show up, she gives the deed to South Florida Lending, who then takes that along and records it. So I think that contradicts this idea explicitly that the deed was given and they had the ability to record it without restriction. The standard here, clear and convincing, again, I point you to a detailed record, long record of all the depositions, of Drapp's testimony, of Street's testimony, of McDaniel's testimony. So, and I do find it troubling that, you know, even here we are 470 something days later after Judge Allen entered her order, that this gentleman, in the desperate condition that he was in at trial, findings of fact about the cancer, his own testimony about his condition. He clearly testified, and I had the stack full of medical records there, and Judge Allen said it wasn't necessary. McDaniel testified that he was suffering from the acute effects of chemotherapy and cancer. And here we are, even in appellate briefs, and we're still disputing. Oh, one other important thing. Remember in the transcript, deposition and at trial, his daughter, the appellant, the defendant, she drove Mr. McDaniel to hospice. And remember, there's that exchange in there when I said, well, when did he get out of hospice or whatever? And she you know, says she's got this medical background. When someone's delivered to hospice, they're not intended to leave hospice. So you ask the question, what's the evidence about his condition right around that period of time? It was that she delivered him to hospice. So if I could just take a deep breath and focus on this intervener thing, because this becomes very problematic. The court will recollect and see from the record, we had been hotly litigating this case for 2 years, and the defendants, as the trial transcript reflects, had been concealing information. Remember that testimony about trade secret confidentiality, and the witness, this Drapp on stand, didn't want to talk about this transaction between the intervener and herself and Mr. Street. And Judge Allen says, you can't conceal that. What are you talking about? And so finally this is revealed. But I quote in our case, and I quoted it in the objection to the intervention of South Florida, the Union National case, and this case standing for the proposition that if you're granted intervention, you don't get to come into court and make an interference with all of the case that we're doing. In fact, the case cites, and it says very clearly, that Union Central may monitor the case as a spectator. And that is what South Florida should be granted here. They should be granted only the opportunity to, as Union Central asserts, monitor this case as a spectator. I share the confusion that Judge Casanova experienced here at the front end with the mechanics of this, and that's what happens with the docket there. 10 days before trial that had been litigated for 2 years or more in depositions and everything else, the intervener comes in over my objection. Not a first pleading is filed, no discovery is held, nothing whatsoever. They jump in. At trial, they say, I'm here and I'm co-counsel for Miss Allison. And that just confuses everything, but they get a full opportunity to participate in the proceedings. They didn't ask for a continuance so that they could file. They didn't do anything other than be granted the right to come into court and intervene. And I say sit as a participant, but only monitor. So now Judge Allen enters her final judgment. And now the intervener, South Florida, is given a right to fully participate in these appellate proceedings. And I just don't believe that that's what intervention provides. I draw the court's attention to another very important point. There is a Liz pendant required, two actually. There are 2 Liz pendants filed, one in February, one in April. A full year or whatever before these other deeds are recorded and before South Florida comes in. So if you're going to write anything, and we're going to talk about intervention, you need to recognize this concept of purchaser pendant lite. They take the pleadings and they take this case and that property subject to that Liz pendants. They know about it. They're deemed notice, constructive and active notice. They in fact had active notice. So they jump into the middle of this, but that doesn't give them the opportunity to interfere with these proceedings in the manner in which they did. Again, part of the confusion at the appellate level is the initial brief is filed by intervener South Florida Lending. Well, how do you get to file a full brief arguing all of these things that occurred down at trial court that you didn't participate in at all? How do you get to file a full appellate brief that I didn't have the opportunity to challenge any of the facts or assertions that you're making in there? It's not fair to me. It's not fair to the judge for her opinion to be challenged by a person, by a party that wasn't a party. They were only an intervener. And now here we sit today at an appellate oral argument where likewise intervener is able to come in having not participated at all at the proceedings. And one of the particularly irksome things that I find is that they are telling this appellate panel, they being the intervener, that the trial judge erred in not considering all the evidence when in fact the appellant spent 2 years not producing evidence, engaging in these dilatory tactics, and in not producing the agreement. And now the appellant, or the intervener, comes in and says, hey, judges, you should reverse this because of an insufficiency of evidence when the appellants didn't participate and produce their evidence at court, at trial. So for all of the reasons that are asserted here, I just strongly encourage the court to affirm the judgment. You know, as to the vulnerable adult and as to the another one, 817-535, the false reporting, you know, we put all of that into the complaint. We put them on notice of it. Those are 2 causes of action that are critical in this era, but there's no reported opinions on there. Just was a June opinion reported on the false recording 817 statute, and nothing on the 415 civil action for vulnerable adult statute. And I think that's problematic. These are 2 relatively recent statutes that are out. The only reason I dropped those counts was because it was clear that the court had all of the facts in her possession to render the judgment that was necessary based on the Declaratory Judgment Act. And so those other things, while they were pled and they were in fact dropped at trial, weren't necessary and are not dispositive of the final judgment, 11 pages long, entered in this case. Judge, I'll respond and reserve any questions that the court has.
I don't see any questions from my brethren. So I will thank you for your presentation today. Move on to Mr. Dogali with the understanding you have 2 minutes remaining, sir.
Thank you, Your Honor. If the idea is you're required under the law to deem South Florida Lending Corporation just a monitor and a spectator at this trial, then I'd ask you to enter an order to that effect here. That's all South Florida Lending was, as Mr. Widener indicated. So that would mean the judgment entered by Judge Allen has no res judicata or collateral estoppel effect on South Florida Lending Corporation. So I invite you to do that. If for chance you should not, I address in my 2 minutes only a couple of points. One is there was a statement that everybody agrees the property is worth well in excess of $500,000. It's absolutely not true. There was no evidence to that insofar as I mentioned before, that's the assessed value, but there was no establishment of what liens might exist against it, et cetera. There was a statement that the judge did not overturn the 2016 deed, but instead upheld it. That's simply unsound under her judgment. It concludes with a direction that the clerk remove it from the official records and that it's declared void. In that respect, if Mr. Widener were correct, and all we do is, okay, the deed should be upheld, and that was a mistake in the judgment, should be corrected so it's not actually voided, but it was never delivered or title never passed. All you would do is enter an order affirming or reversing as to that. We go back in time and then decide when did title pass, if it did, and litigate the issue of what happened next, because the deed is valid. And so did he engage, did he take title after a default on the underlying loan or not? Or was recordation title, what impact did lease pendants have? Finally, there was the notion of the 2017 deeds having been abandoned. They were actually presented in the trial. Mr. Widener said several times that we ask you to declare the 2016 deed and the 2017 deeds null and void. And that's what she did. There was no evidence presented about the 2017s. Critical to those deeds would be the power of attorney. Whether if Ms. Drapp may have had the power to convey those deeds in 2017. What happened?
I need to advise you that your time has well expired.
I'm sorry, Your Honors. They offered nothing about revocation of the power of attorney in this record. Thank you, Your Honors. I appreciate it.
Thank you. We will conclude with Attorney Allison. You'll need to turn your mic on, please.
Thank you, Judge. You're a mind reader. I will say, record page 119, the value of the property, according to the tax bill that my client paid, that the taxable value is $146,514, and the assessed value is $132,000. So again, what Judge Black, you probably feel as if Mr. Widener never answered your questions, and he didn't. And he did similar things at trial where he makes up stuff. And then when you ask him to cite to the record, or what I did at trial, I said, object, you need to cite the deposition. You're saying my client said that. I want the page number and the line number. And the judge kept getting mad at me because it was taking too long. But he just makes up stuff as he goes. And actually, he said a lot today that's not in his answer brief as far as my clients go. So he should be limited for both appellants to what he has in his brief. And he just added a bunch to that. Finally, I'll say this is no joke to void a deed. My client was in the middle of a divorce. Her father palled up with the ex-husband, which was her husband at the time, and made her life hellish. And this was one way they did it. Now, you can tell the way Mr. Widener talks, oh, well, Dr. Drapp held on to the deed, and well, it sounds like his client, the appellee, was very competent at that time, the way Mr. Widener presents the story. Oh, well, hold on to the deed. So they go in and out of this reality as it suits them, which should be your first tip off that something smells. And then the second thing is, again, my client didn't make anything off of this. She had a headache and a bunch of litigation to deal with. And she ended up, she wanted her money back. Her father would not repay it. She gave him a longer time than originally agreed. Okay. And you know that recording a deed has nothing to do with delivery. The day they executed the deed, August 4th, and it's in my brief, which cites the record, Dr. Drapp received the deed from her father. She was nice enough to say, look, the deal is you're supposed to pay me back. I need the money. I don't have money to repay Mr. Strife. So the fact that my client, kept her word should not operate against her at this point. But it might be smart to record a deed, but it has nothing to do with delivery or validity of a deed. We all know that. So that's a bogus argument right off the bat. And again, I would ask Mr. Widener to cite these places where he says people said this or that. He needs to.
He has no time left to respond, so your argument should be directed to the court.
Understood. But attorneys' arguments are not evidence. He should know that by now. That he points, when you look at his cites, they're to his argument or his complaint, which do not constitute evidence. Now, again, I get back to the standard that. The burden is on those seeking to set aside a deed to show such fact, since the presumption always supports the validity of the deed. So we have a strong presumption that the deeds are valid, and there is no evidence other than the notary's testimony. He's the only guy that didn't have a dog in the fight, and he testified and wrote an affidavit that he knows Mr. McDaniel, and there was nothing wrong with him that day. And that was the only document that was signed and notarized that day. So there was no way that you could get it mixed up with something else. If you look at he being the only objective person versus the appellants and the appellee, he's really the one you have to go with. And he said that there was nothing wrong and there was nothing fishy.
I don't think we get to go with anyone. The trial court comes up presumptively correct. The trial court weighs the witnesses. We measure the quantum of evidence perhaps, but I don't think we get to pass on as though we were trial judges, even though some members of the panel have been.
Well, Judge, the thing is, the trial judge messed up, made a legal error and using the wrong level of evidence. I'm not sure which level she used, but it's not clear and convincing. And she also used the wrong standard of vulnerable adult to void a deed, which I cover extensively in my brief. So I won't repeat all of that because
Well,
I don't have the time.
that's appropriate as your time expired a little bit ago.
Okay,
So
thank you,
that
Judge.
concludes our arguments on this matter today. I thank you all for being with us and stay safe and well. And
Thank you,
Thank you, Judge.
Thank you.
I'd like to thank the clerk for doing an excellent job of organizing all of these.
Clerk and the marshal appreciate that.